War. Oh, it's a pirate law, the rule of parley. So even pirates, you see, have to have some sort of advocacy by virtue of being a pirate. To have these parleys and negotiations, they need to be advocates of some kind. Anyway, I hope that's brought another smile to your face. Now, take that off. Ah, dear. Right, I've just been out. Cool. Hair is long. You couldn't wear this as a judge, this hair, although you put a wig up, that looks very much the same on top and nobody says anything. Right, I thought it would be a bit of fun now. Let's just have a look at this. You arrive at the court, it's your first day in court, and you've got no notes, you just know you're going to represent somebody called Ivor Swag. Do you get that? Ivor Swag. Okay, and he lives at 21 Nick Lane. Anyway, what can you get in a few minutes? Well, theft of property, 1 radio, £20. Facts, he stole the radio from the shop. Explanation, he needed the money. He made a statement to the police, prosecution agree that, and recovered the property for the man damage. That's agreed. He's aged 19, just a little older than a boy. Lives at home with mum and dad at 21 Nick Lane. And his mum, should you need a surety, is Rosie Swag, off the same address. They live together. Unemployed for the last 6 months, but he has expectation of a job next week. Right, well, it's up to you whether you phone and verify that job, your job for sure, or whether you rely on instructions. Anyway, you can never mislead a court, remember. It's probably worthwhile remembering when you take instructions, particularly when you first start, remember it's very important not to lead your instructions or the person giving you instructions in any way which creates a defence room, because that's a very serious thing to do. And in your youthful joy of being newly qualified and huge amount of knowledge in your brain, you know, you've got to be careful you don't give the hint that allows somebody to create a defence. Anyway, that's all I need to say about that. It's self-evident, really. Does he have a previous record? Yes, he does. 10 months ago, he goes first offence, theft, fined. 8 months ago, theft, fined. 4 months ago, he was placed on probation for theft. But he was on bail for that offence, and he committed 1 bail act offence of failing to appear. He says he was frightened, but he surrendered. And it was unconditional bail at the time. Right, so that's the brief facts. I mean, I suppose if I thought about it a bit longer, we'd find out why he needed the money. Pick something in your own mind which is sympathetic. That will do fine for the purposes of the illustration. Prosecution object to bail if it proceeds to a bail application, because you can't deal with it today. You probably need reports anyway, because he's on probation in any event. Although you can do stand-down reports these days. But anyway, if granted bail, they say your client, my client, our client, will Ivor Swag will do a runner. He'll abscond, and they base that on his previous record, including the 1 bail act offence. And they say they'll also commit further offences because he's committed thefts in the past, and therefore he'll continue to do thefts. He's a professional thief. That's what they'll say. And let's throw in for good luck, it's a serious offence, and that might scare him off. Well, let's deal with the last one first. That's nonsense, isn't it? Theft, shoplifting is not so serious offence that people are going to run inherently because of itself. And in any event, the Bail Act doesn't preclude people with serious offences getting bail. So there we go. Let's put that to one side now. So let's think about that. Up gets you, young barrister, you say, my client instructs me to apply for bail. Now, that's something I don't like. My client instructs me to do this. My client instructs me to do that. That's basically telling the judge or any professional quorum that really you're not having any faith in what you're doing. You're basically just doing what you're instructed, and you don't have any commitment. And it's nothing to do with you. And that's bad advocacy. Shouldn't be done. Strongly urge you against that. But the court already knows you're applying for bail because you are doing it. Right. Then you get up and you say, he's a young man of 19 that lives with his family at 21 Nick Lane. So what? What does that mean? What do you draw from that? Well, if you're doing the bail application properly, you'd need to draw a conclusion for why that's important. Fixed address, security of address. He'll abide by any conditions attached to bail. Yes, and why? He has treated bail before, but he's frightened. So what? What did he do? Well, of course, he surrendered. Job prospect next week. Property was recovered and he cooperated. How does that affect bail? I ask you to allow my client bail. Well, there you go. Done. Says all the facts. But really, it's not the ideal bail application, is it? Because you've got to get a bit more enthusiastic about it. You know, same application, let's say. If it's a lay bench, you could talk very briefly about the bail act. Bear in mind, I wouldn't do that if they're self-evidently an experienced bench, because you already insult them. If there's anything in the bail act, the law itself, that you really want to draw attention to it. Now, you say that, you know, the prosecution say that my client may abscond. Well, this happened before, but he was frightened. But the important point, he surrendered, and he has been complying with the probation order, he didn't run away. He's appeared at court. He appeared at court after he was surrendered to the police station in the last case, if that's the case. Consider strong ties with the community in the area. This is his family. Soon be working. Mum and dad are in the back of court. Family support. You never had bail conditions before. You can now impose bail conditions. You might want to indicate what those could be. Hasn't received a custodial sentence. Or indeed, he hasn't received a community order yet, apart from the probation order. In fact, they don't call it probation anymore, do they? Anyway, and not even a suspended sentence. So, an immediate custodial sentence isn't forthcoming or likely to happen immediately. God, that's bad, isn't it? Gambling on like that. And the defendant's mother is in court as a surety, should she be required. Further offences, well, he's got previous convictions, pretty bad if it comes to his general record. But the good thing about bail is he's had it in the past, he's complied with it, and he surrendered when he in fact breached it, and it wasn't on the run. So that needs to be taken in context. And then you can have conditions of, say, for example, reporting. Gets a job, he'll be earning money, occupying him all day. So there we go. That's a general impression of how I would do it. I suppose one draw attention to the 19 years of age. And then let's just take another quick example for me. Ena Boggins, age 78, 15 Grays Avenue. You got to court with that. Stole 1 lamb chop, 6 sausages, 1 packet of stuffing worth from Grabbitt's supermarket. Well, nowadays that'd be a lot of money, wouldn't it? Lamb chop, my goodness, what that costs. Anyway, she said she walked into stock, do the normal shopping. She was 40 quid with her. She was going to pay a telephone bill, which was 30. She picked up several items, placed the other items in the bag, went to the till, paid for some, but not for all of it. She said, I had the money, I should have paid, didn't do it. I don't know why I didn't do it. I knew what I was doing was wrong. Now, this happens a lot. But of course, you know, she might well have known what she's doing was wrong now. The question is, was she in a state of consciousness, an altered state of consciousness at the time she stole the meat? So anyway, for the sake of today, we'll talk about it as a guilty plea. Never been in trouble before. Taken to the police station. Never been implied at the police station before. Police officers, but I was scared stiff. Do not want to be papers. Married with a husband who's 84. 3 children, all grown up and married. Cannot sleep. Husband retired, and she was 20 years a dinner lady, living on a pension. Hobbing, gardening, find it difficult to make ends meet, but managed to do so. Credit for guilty plea. and saving and everything being recovered. Right, so how would you approach this? Well, there's lots to say here. The first thing is, if you've got a district judge or a professional judge, indeed with the experienced bench, you may be able to say something along the lines of, well, you've heard the facts in this case and no previous convictions, everything covered, early thing, age of the defendant. You may feel a discharge might be the appropriate way. If you are minded to do that, I needn't address you further. Perfectly good advocacy, that. You don't have to talk for 4 hours. Incidentally, I remember my first shoplifting plea was a young girl, and I must have spoken, those poor magistrates must have sitting to listen to me whittle on for about 2 hours about something which was from the very beginning going to be an absolute discharge or a conditional discharge, but I went on and did with it. So anyway, I was going to just run through the what one could say, but I think it's self-evident what you can say. I think one thing you should cover in this, which is not self-evident, which is not clear on the facts, and that is that she first time she'd be extremely worried. She's not been sleeping. The anxiety and the stress for somebody that age should not be overlooked. In fact, that you could almost say that that's probably the kind of punishment which overwhelms anything a court could do, let alone the threat of the publication in the press. If you wanted to, in a case like this, you could beef it up with a letter from the husband, the school headmistress saying she'd worked there for 20 years, and doctor's letter if it's that kind of case where she'd been to see the doctor. Incidentally, when you take instructions and people are worrying like that, it often does pay to advise them to see a doctor, not just for mitigation or any other reason, but for the concern for your client. Anyway, so that's just a quick bit of diversion. I think what we'll do is just deal now with the types of benches, different benches you get. District judge, magistrates court, district judge, civil court. The difference is that a district judge in the magistrates court is actually appointed by a royal warrant, and the civil district judge isn't. Both can be addressed as sir. I think a coroner also is addressed as sir. With lay benches, you often hear police officers saying your worships. Please, it's not necessary to do that. Just sir or madam, depending on who's the chairperson, will do. The worships come back from when the Lord Mayor was the Honorary Justice of the Peace. So really, there's no reason to call them that at all. Now, over my career, listening to other advocates, there's often a criticism by lawyers calling magistrates wooden tops, not good enough. You've got to be very careful with that attitude. My experience of lay magistrates has always been very good. I think they do their best, they try hard, they've got legal advisors to deal with them in court, to advise them on the law. They can deal with the facts, they can work out what's dishonest, what isn't dishonest. And I think, my point of view, it's like a mini jury in some respects, and it gives you the benefit of being judged by your peers. And I say that as a district judge who's judged cases himself. And also, listen, lay magistrates could have a law degree, they could be a retired judge, they could be still sitting, they could be law lecturers, they could be people of industry, far removed from people that are ill-equipped to deal with this. So you've got to be careful what you're doing. I'm going to talk about finding out about the quorum that you're dealing with. It's important what the judge is like and what his idiosyncrasies are, or the lay bench. So many of them have years of experience. And remember, they are capable of doing the job. It's your job, our job as advocates, to make sure that a jury or lay magistrates understand what the case is about, whether you prosecute or defend. Skeleton arguments, make sure they're nice and easy so everybody can read them without being overwhelmed with authorities. In the Crown Court, of course, it's Your Honour, High Court, my Lord, and the professional colleagues. For some reason, a barrister's my learned friend, and I was just my friend. And even as a High Court advocate, you're just your friend. I wonder if they should call us my higher friend. I don't think I'll object to that. Anyway, I never wanted to wear a wig, which I think we all do now, High Court advocates. I was quite proud to be a solicitor, but I had some funny times. So when solicitors have always had rights of audience in the Crown Court, and I've had experiences in the Crown Court doing appeals and so on. I won't mention names, but one time I was went to change, I think it was Knightsbridge Crown Court or something like that, and I was told that I couldn't use the bar robing room since I wasn't a barrister. I'd go and use the toilet. I wasn't allowed in the bar mess, so I had to sit outside Westminster with the Guildhall. I had to go and use the van where the taxi drivers, good bunch they were too, had their sarnies. And then once at the Bailey, I was told that as a solicitor I shouldn't be there. I mean, this is all years ago, you know, it's not like that now, but I just thought I'd just mention it now because it happened, you know, so no point in not saying it didn't happen. It did happen. So there was a kind of distinction. I think when Solicitor High Court advocates came out, it was a mistake not to have training. I think now there is training, because there's a huge difference between being a solicitor in the Magistrates Court for 20, 30 years and then appearing in the Crown Court. I mean, I know that because I've done both. I'm not just making it up. Even sitting as a judge without even being a barrister in the Crown Court was difficult. Not impossible, but, you know, again, worth mentioning. So anyway, once you can now have to call everybody else. There is a distinction between the bar and solicitors, I think, thinking about it. I think there's a lot of prima donnas at the bar, perhaps less so solicitors. Anyway, that's bound to get some sort of comment, I suspect. But I don't remember many solicitors having a champagne on a Friday afternoon. But I do know lots of chambers used to do that years ago. Anyway, remember, it's the advocate's job to assist the judge in the law. You can't expect a judge to know everything, particularly regulatory offences, for example. And then on the next talk that I'm going to give, I'm going to talk about how you approach the preparation in terms of the advocacy that you're going to be doing, because basically the whole case is designed for your closing speech, isn't it? That's where you're aiming for. The closing speech is where you sell your goods, and that's what we'll talk about next time. Anyway, that's enough for today. Do remember, this is only a sort of like a ramble. I can't even say there's a huge amount of logic behind the way I'm going. And of course, in a proper case preparation, you would have a chronology or some plan about how you were progressing. Whereas this, there's no real time chronology in this. It's more like a waffle, really. But I've tried to put the waffle in some kind of collected groups. We'll see how it goes. But where I've got it wrong, it's a good illustration of, you know, things could be done better. And that's it. So we'll see how that goes. Now I want to try this thing here, this button thing. Let's turn it off.